Okay, we call 24 CR 2405. Please have a seat. The state of Texas versus Matthew Smith. That's you, sir. Present with John West, your attorney. Is all of that correct? There's a motion to revoke unadjudicated probation that was filed October 17th, 2025. The parties ready, state and defense.
Defense is ready, Your Honor.
All right. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Your Honor.
And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand, please. In summary, this motion to revoke unadjudicated probation filed by the state of Texas states that on June 24th, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for injury, stand by, it says to a child or elderly person. It looks like an elderly person, age 65 years of age or older. Is that true? Is that what you're on probation for?
He laid down in front of my room.
Okay, is that what you're on probation for?
That was a yes or no.
Are you on probation?
Is that what your probation, are you on probation for that indictment, alleging that?
Yes, but I didn't do anything. He pulled my foot down onto his face.
I'm sorry.
I didn't leave my room.
I'm sorry.
That's all that happened.
Hold on. I thought you pleaded guilty.
The judge told me to.
Did you interrupt me?
In Texas, Matthew Smith faced a motion to revoke his deferred probation for injury to an elderly person. The judge reviewed alleged violations like a THC positive test, missing rehab proof, no community service, unpaid fees, and continued contact with the victim. But Smith repeatedly interrupted, denied guilt, and seemed confused about what pleading guilty even meant. The courtroom tension rose fast, and the judge started questioning whether something deeper was going on.
We can't both speak at the same time. This lady needs to, the court reporter is the most important person right here. When both of us speak over each other, which is rude, she can't do her job. Would you be so kind to follow the rules, sir?
Yes, sir.
Thank you. I'm sorry. There is a judgment that states you pleaded guilty on June 23rd, 2025. And here is an order of deferred adjudication placing you on deferred or unadjudicated probation. You waived your right to a jury trial by jury and entered the plea of guilty to this. Are you saying this is a false judgment? Okay, I signed it. It is not false. It's a valid judgment.
No, sir, I didn't. You weren't there. My mom was there. My dad laid down in front of my room.
No, sir. When you pleaded guilty in court is what we're talking about. You pleaded guilty.
I'm on Social Security, sir. I'm having problems reading the system. The thing is I was in my home, and my dad laid in front of my room, and I tried to walk out there, and he
once again, did you plead guilty?
I don't know what that means. I was told I was guilty because I was there. He said I was guilty because I was there. I told him my mom was in the house.
Who represented you at the plea hearing?
What is false?
John West?
No, I wasn't an attorney.
Who was the attorney?
Miss Rinaldi.
I'm going to ask the bailiff to hand John the document, show him those documents, point where he signed, and I want you to tell me whether that is your signature or not, since we all saw you sign it.
That's my signature.
All right. Then that is a judgment you signed, sir, admitting guilt.
But I'm not guilty.
Well, you shouldn't have, I'm sorry.
There.
Then you shouldn't have committed perjury when you signed that under oath.
No, I don't know what I'm doing. My mom is my legal.
I'm sorry, sir. I'm sorry, sir.
When the police came to my house, they were bribed with money. They took me to jail for a long time, and I've not done anything to anyone. My father literally pulled my leg down onto him as I was stepping over him. I could not see my leg being grabbed at until I was over him, and he would not let my foot go. And then he proceeded to eat on my shoe. I didn't do anything to him.
All right. Then the state may go forward with the presentation of the evidence in this case. Among other things, this states that you failed to avoid injurious and vicious habits as directed by the court, and you tested positive for tetrahydrocannabinol on or about September 29th, 2025. in violation of your probation order. Is that true or untrue?
I walked in there and
Is that true or untrue?
I'm trying to tell you something.
No, sir. True or untrue? You
You
will.
feel someone else's THC in the room on the guy that's supposedly
Then
testing.
untrue will be entered. And if you keep speaking,
No, I have not bought it. I haven't had any.
if you keep speaking over the courts, then you will be placed in another room and you will be listening to it in that room by being rude and abusive. Please follow the rules. These are simple.
True.
We learned this in first grade, not to interrupt people like you're doing. Number two, you provided a urine sample on or about September 29th, 2025, which showed tetrahydrocannabinol, THC, in your system. Is that true or untrue?
No,
It's true or untrue?
true.
All right. Untrue will be entered on your behalf. 3, you failed to provide verification of attending rehabilitation, treatment, residential programs, and counseling as directed by the probation officer in violation of your probation order. Is that true or untrue?
I can't hear you on untrue.
4, you failed to provide verification performing community service hours as required by the court in your probation order. Is that true or untrue? Untrue will be entered on your behalf. 5, you failed to provide verification of entering and successfully completing the anger management program as required by your deferred adjudication order. True or untrue?
Untrue.
6, you had contact with the victim, Craig Copeland, of the offense either in person or telephone, via mail, or through a third party by continuing to reside with the victim in the residence where the alleged offense occurred, which is in violation of condition 27 of your deferred adjudication order. Is that true or untrue?
Untrue.
And finally, you failed to pay court-assessed fees as directed as of September 29th, 2025. You were $400 in arrears, which is in violation of condition 35 of your deferred adjudication order. Is that true or untrue? Untrue will be entered into your on your behalf. All right. This is again a motion that was filed on October 17th, 2025, and the state may go forward with its first witness.
Step call, Alex Hill.
Come forward. Thank you. Raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yeah.
Thank you. Please have a seat. Go ahead.
State your name for the record, please.
Alex Hill.
And what do you do for a living, sir?
I work for the Justice
In what capacity?
Community supervision.
And in that capacity, have you dealt with an individual with the name of Matthew Allen Smith?
I have.
Do you see him here in the courtroom today?
Yes, sir, I do.
Can you point to him and identify something that he's wearing?
He's wearing a red inmate jumpsuit.
Your Honor, may the record reflect he's identified the defendant, Matthew Allen Smith.
Yes, it will.
All right, so Mr. Hill, when did you first come into contact with Mr. Smith?
I began supervising Mr. Smith since the initial.
From the onset?
Yes, sir.
Is that for a probation order that was entered on June 23rd, 2025?
Yes, sir.
Was that in cause number 24 DCCR 2405?
Yes, sir.
For the offense of injury to, in this case, an elderly individual?
That's correct.
All right. You've watched the initial proceedings with the judge and Mr. Smith
You mean today?
today.
Yes, sir.
Is this how he has normally appeared with you in your dealings since June of last year?
Yes. Yes, sir.
Has that made it really difficult to work with him as far as probation is concerned?
It has, yes, sir.
Is one of the immediate concerns represented in the allegation about a violation of condition 12, which is that giving him a schedule for a mental health evaluation?
Yes.
Did you basically assess that we needed to do that?
Yes, sir.
And has he complied with your request to go forward and do that?
No, sir, it is not.
tell the judge what you've been dealing with and trying to get some success in evaluating his mental health so we can treat and address this issue.
It's very difficult. Mr. Smith is not compliant with our requests. And he just has a difficult time.
Other than, say, the conduct that we've seen today, what are some other indications that he may have some mental health issues?
Mr. Smith goes into ramblings about medical procedures that have been done. He made allegations that his father has sexually assaulted him on numerous occasions, and there's assaultive behavior in the home, which they're currently residing in together.
Right. So I'm going to segue from what you just said to one of the other violations. And that's about him still having contact with Mr. Copeland.
Yes, sir.
Describe to the court what's going on with the living arrangements and the contact with the victim of the offense.
Mr. Smith has reported to me that both him and his father still live in the home where the alleged offense was to have occurred.
It's not an alleged offense. He's already pled to it.
Correct. Where the offense occurred.
Right. So they're still living together?
Yes, sir.
Why are they still living together?
My understanding is that the defendant's mother is his beneficiary to his benefits that he receives. And so he doesn't have access to those funds. And so he's living with his father at the residence.
Have you dealt with his mother?
I've spoken to her.
You see her here in the courtroom?
Yes,
today?
she's in the courtroom.
And are you suggesting that she's not allowing him to move outside of the home?
Like I said, I'm not too sure of the specifics, but I know for a fact that she does receive his benefits and is his beneficiary.
All right. So you know that she's over his money,
Yes,
but yet he's still living with his dad,
correct.
Mr. Copeland. Mr. Copeland is not his biological father, is he?
I'm unaware.
All right, so let's go back up to this administrative hearing. Was that conducted on September 29th of 2025?
Yes, sir, it was.
Did he voluntarily appear as summoned?
Yes,
When is that when you confronted him about a positive test for THC, or was that when the test was done?
the test was done on that date.
Okay,
It was during the administrative hearing, so that the results were discussed.
all right, so it sounds like he appeared and then y'all had the test done and then conducted the hearing?
Yes, sir, correct.
All right. So tell the judge what he said when it became obvious that he had tested positive for THC.
Mr. Copeland stated, quote, "I will not stop using drugs." And he was referencing THC.
Stand by just a second. I'm on warrant duty right now. Okay. Thank you. Go ahead.
All right, so just to try to get to succinct, on September 29th, he did test positive for what drug?
THC.
This was September 29th, 2025.
Thank you, Judge.
Yes, sir.
Okay.
I apologize. I didn't say the year. That was within the last couple of months if this happened, correct?
Yes, sir.
And when you told him about that in the administrative hearing, he made a really obscure statement to you.
Yes, sir.
What was that statement?
He said, quote, "I will not stop using drugs." He was referencing THC. He said, "You can't make me. I'm a badass."
So
I'm a what?
A badass.
So in other words, you're trying to seek his compliance about following the rules, and his references, I'm not going to stop doing that.
Then came the turning point. The judge refused to move forward without knowing if Smith was legally competent. After hearing the rambling, incoherent responses, the court ordered a psychiatric competency evaluation before any disposition could happen. The judge made it clear, mental illness, competency, and legal responsibility are not the same, and the court can't proceed if competency is in doubt. The revocation hearing was paused immediately, and the case was set to resume after the expert report.
Didn't make any of the statements like what you heard here in the courtroom. But I followed somebody else into the.
No, sir.
Did you do your analysis?
I don't believe I did.
Okay. All right. So as to just in general, is it true that he hasn't done any community service hours?
That's correct.
And Although he's given it, he still could catch up. As of right now, he hasn't done anything.
Yes, sir, as of today.
And was he instructed to take and sign up for the anger management class?
Yes, sir.
Did he make any steps towards doing that?
No, sir, no documentation of completing any type of course has been provided.
All right, so since June 23rd, he hasn't done any community service hours, hasn't done the anger management class.
Correct.
Has he paid toward his fees?
No, sir, no payment has been made.
That's where the $400 arrears is how much he should have been at the time in
Yes,
which
sir,
it
at the
was filed.
time, yes, sir.
But no payment since then.
No payment since,
So no payments, no fees, been reporting.
until his arrest, yes, sir.
And when you confronted about the drug use, you got that statement.
Yeah.
All right. Were options given to him about how he needed to move from where he was living so that he gets away from Mr. Copeland?
We instructed him that he is required to move. He is to have no contact with this victim whatsoever. And we did give options of assistance.
When did you get those instructions?
Those were, he's met with myself and my supervisor on several different occasions, and those instructions.
So all those are in advance of us filing this motion.
Yes.
He just hasn't done it.
Sounds like he's at least checking in with you on a regular basis, correct?
Yes, sir. He reported until his arrest.
So he was reporting and doing that part, correct?
Yes.
Okay. And as far as his drug test, had he ever tested positive before that?
That was our first drug.
Okay, so you hadn't tested any time before that.
No, sir.
Okay. And then obviously there's no test since then because he's been in custody since. Okay. And how long has he been on probation? Just a few months at that point?
Since June. so
Okay.
3 months.
So as far as the community service goes, he's still early on his probation, correct?
Yes, sir.
Okay. So even though he's behind or hasn't done any, he still can do community service. Okay. And as far as him living with his father, that's where he was living before this happened, correct?
Since the incident is what I'm understanding.
Okay, okay. And he doesn't have a real place to go, does he? As far as you know.
Not that I know.
Okay. That's why y'all were giving him help and assistance on being able to find a place to go. Right, right. It's not like he has his own place and just chooses not to stay there, right?
Correct, yeah.
Okay. That's what it is.
Anything else?
No further questions.
All right. Let me ask this. I mean, is this defense contending there is an issue on competency here?
Your Honor, he
From
was told
what,
to be competent. I'm
sir?
not sure.
Well, you heard what he said.
I know.
You heard what, this is all on the record. Does that bother anybody?
Bothers me a lot.
Bothers me.
Yeah.
Who said that? You can, don't make outbursts from the crowd, please, ma'am. We'll take care of this unless they call you as a witness. What's the state say?
About his competence, Judge?
A question of his competence. I mean, that's a first, I mean, that's an important thing. People have to be competent before they can be ruled upon by a court. I think there's a question of it.
That's totally up to you.
Well, okay.
I am certainly not somebody.
I'm going to
in a
order,
position.
I'm going to order
I think even-
an evaluation of the defendant. I've heard enough from him. It's incoherent and it bothers me that we're going to go forward and make a disposition without learning whether he's got some competency issues or not.
Your Honor,
Because it's very, his statements are bizarre.
I would
and-
just.
And he's not following the rules of etiquette and the rules that the court is instructing him. So unless otherwise, I'm going to order Dr. Edgar Pond to come in and evaluate the defendant for competency before we move further in this matter.
I would just ask that we recess this matter so that the testimony still stands live as far as what we've done with the cross-examination, so that we don't have to repeat the process.
It's not being erased. It's in the record.
No objection to that.
But once again, we're going to have to replot the land possibly, because if he's incompetent, what he said is not something used by the court for disposition, except for competency determination purposes. Upon for competency, and he will make a report and we will return back and pick up this hearing where we left off. Okay, that is all.